Hello, everyone, and welcome to Uncivil Law. For today's case, we have a decision from the 8th Circuit Court of Appeals. This is the case of Kevin Chestnut versus Officer Darwin Wallace of St. Louis. In this case, Mr. Chestnut was observing the police. The police found him observing to be suspicious. Another police officer went up to him and asked him for information and then detained him. We're here to determine whether or not this was proper and whether or not this was a violation of the Fourth Amendment and whether or not any recovery is possible under 1983 for violation of civil rights. So we're going to review this case and see what happens next. This is an interlocutory appeal, which means it's an appeal while the underlying trial is still ongoing. There's no final verdict from the trial court. From the denial of qualified immunity to police officers who stopped, frisked, and handcuffed a person who had been watching another police officer perform traffic stops. We agree with the district court that genuine issues of material fact preclude the officer from receiving qualified immunity at this stage. We therefore affirm. We're just in bonus time, guys. It is another decision where 1983 immunity is not being conferred. Not being conferred. Is everyone's hope being sufficiently restored yet? That we have another case where 1983 violation is actually being upheld and the officer is not able to escape from it. Let's read on. According to the plaintiff, Kevin Chestnut, one evening around dusk, he paused his jog in a St. Louis park to watch the St. Louis Police Department perform a traffic stop. He watched the stop for 5 or 10 minutes and then resumed his jog. Shortly thereafter, Chestnut stopped again to observe Graham perform another traffic stop. During this stop, Chestnut stood in a grassy area between the jogging trail and the sidewalk and leaned against a tree. He testified that he stood 30 to 40 feet away and across the street from where Graham was conducting the stop. He asserts he was watching stops out of curiosity since there had been a lot of difficulty in citizen-police interaction as of late. The parties point out that this specific park had been the site of testy exchanges between the police and citizens. Chestnut caught Graham's attention. She radioed dispatch for assistance, reporting that a suspicious person had been following her to her car stops. She described Chestnut as a white male in a yellow shirt who had been leaning against a tree across the street from her. Officer Darwin Wallace responded to the call and arrived on scene. From his police call, he saw someone matching Chestnut's description and shined a spotlight on him. Wallace testified at one point that either Graham or the dispatcher had said that Chestnut was hiding in the tree line and kind of peeking and lurking around the tree. Chestnut, on the other hand, testified that he had purposefully stood in a location where the headlights on Graham's car illuminated him. He said that he intentionally made himself plainly visible, he was standing still, and he was not interfering. After shining his spotlight, Wallace got out of his car, approached Chestnut, and asked for some form of identification. Chestnut had none on him, so Wallace asked for his name, address, and social security number. Wallace maintains he requested the information so he could determine whether Chestnut has any outstanding warrants. Chestnut provided his name and, he says, his birth date, but he agreed to provide only the last 4 digits of his social security number. At that point, Wallace frisked Chestnut for weapons but found none, yet he directed other officers who arrived on the scene to put Chestnut in handcuffs. Chestnut then provided his full social security number to Wallace and asked to speak to one of Wallace's supervisors. Wallace used the information to perform a warrants check, and he learned that Chestnut had no outstanding warrants. After Wallace's supervisor arrived and spoke with Chestnut, he directed the handcuffs be removed and permitted Chestnut to leave. Chestnut estimated the entire encounter with Wallace lasted 20 minutes. Chestnut sued Wallace and others not relevant to this appeal for damages under 42 U.S.C. 1983, alleging that Wallace detained, arrested, frisked, and handcuffed him without reasonable suspicion or probable cause to believe he had engaged in or was about to engage in unlawful conduct or that he was armed and dangerous. So this person was handcuffed by the police as part of this interaction. So one of the questions we might have to first resolve is whether this counts as detaining or counts as arrest. So what does the Court of Appeals have to say about that distinction? Before reaching the heart of this appeal, we briefly address Chestnut's contention that he was arrested rather than merely detained. The distinction matters under the Fourth Amendment. An arrest is only valid if there's probable cause to believe a suspect has committed or is about to commit a crime, whereas a brief investigatory detention can be based on only a reasonable suspicion that criminal activity is afoot. A detention can become an arrest if it lasts for an unreasonably long time or if officers use unreasonable force. Though the line between the two can be hazy, we think our precedent squarely places Chestnut's seizure on the detention side of the line. The Waters case involves a 20-minute interaction that was arguably more intrusive than the one here. The suspect was placed in a police car for 20 minutes while handcuffed, and yet we held that that suspect had only been detained. We see no reason why that case does not control, and so we conclude that this detention did not become an arrest. So one of the distinctions between detention and arrest is time period and severity of the action, and here it was a relatively short period. He was being detained, but he wasn't being arrested. So, all those people who always yell, "Am I being detained?" That's actually technically a proper question, because there's a legal distinction between detention and arrest. So, yeah, carrying on. Chestnut's refusal to supply his full social security number to a police officer during a consensual encounter should not have contributed to Wallace's reasonable suspicion. If a person's decision during a consensual police encounter to ignore the police and go about his business cannot be considered a reasonable suspicion, then a person's refusal to provide only some of requested information cannot be either. It would make no sense to require an officer to allow someone who provides no information to walk away, but then permit an officer to detain someone who gives them only partial information. And we do not believe the encounter became non-consensual when Wallace asked Chestnut for identifying information. As the Supreme Court has explained, interrogation relying on one's identity or request for identity by the police does not, in and of itself, constitute a Fourth Amendment seizure. So a police officer is free to ask a person for identification without implicating the Fourth Amendment. So here, at the initial start, there was no detention. At the initial start, it was what we would consider a voluntary encounter. So the police officer came up to this guy and wanted to talk to him. Anyone could do that. Anyone could walk up to this guy and talk to him. So the police are no more privileged a position than anyone else. And they asked this guy some questions. What is your name? What is your address? What's your birth date? What is your social security number? He now, according to the case law, he could have walked away at that point. He could have just walked away because it's a consensual encounter. So he doesn't have to do anything, but he gave some information, but not other information. So the police can't use the fact he gave only partial information to deny his rights. So that doesn't make any sense. If you can walk away after only giving some information. So if it was a consensual encounter, he had the right to walk away. You, the police, are the one who turned it from a consensual encounter into a non-consensual encounter by actually handcuffing him. That was the problem. It is disputed whether Chestnut obscured himself in a dark area of the park to watch Graham. Chestnut said he remained purposely visible and in the open, illuminated by the headlights. We take the facts in the light most favorable to Chestnut. The dissent seeks to justify the seizure because Wallace could reasonably suspect that Chestnut was intent on criminal conduct, since individuals who are merely interested in police conduct generally make their presence more apparent. But Chestnut says he was apparent, and at this stage we must take him at his word. The dissent opines that Chestnut's description of where he was standing merely reflects his subjective intent. With respect, we disagree. Chestnut testified to physical facts, not his intent. He described where he was standing and was stated he was visible. He also stated there was light outside when he was watching Graham, so we cannot say at this point, as the dissent does, that Chestnut was simply following her on the night she made her stops. Simply put, there are issues of facts here. We agree with the district court that if we view the facts in the most favorable way, that Wallace has violated Chestnut's clearly constitutional rights. In a prior case, attorney John Walker observed an encounter between police and some young men. We said that Walker stood with his arms folded some 40 to 50 feet away from the conversation between the police and the young men and did not speak to anyone. When the officers asked him what he was doing, he responded that he was watching the town's finest in action. Nice touch. After a further conversation, Walker identified himself as an attorney and offered his driver's license to one of the officers, but the officer instead handcuffed Walker, put him in the back of a hot police car for 20 minutes, and drove him to the police station. Walker was charged with obstructing governmental operations by, standing by and watching somehow. The purely legal question was whether the officer had arguable probable cause to arrest Walker for obstructing governmental operations because Walker distracted officers who were conducting a traffic stop by simply watching the encounter from across the street with arms folded in a disapproving manner. This does not qualify as obstruction on any level. In ruling for Walker, We explained that in a democracy, public officials have no general privilege to avoid publicity and embarrassment by preventing public scrutiny of their actions. We noted that public police activity invariably draws a crowd of interested but benign onlookers. And we thought it preposterous that a silent, non-interfering onlooker could have distracted the officers from safely completing the traffic stop. We conclude that no reasonable police officer could believe they had arguable probable suspicion to arrest such an onlooker in this situation for obstruction of government operations or for any other possible crime. We think our prior case law establishes that Wallace violated Chestnut's rights to watch the police interaction at a distance without interfering. The dissent says our definition of the right is defined too abstractly and at too high a level of generality. We respectfully disagree. We think we have correctly characterized the principle acted on in Walker, and thus the right in question, and conclude that Chestnut has carried his burden to show that Walker has clearly established such a right. Other legal authorities fully support our holding that the right here was clearly established. Every circuit court to have considered the question has held that a person has the right to record police activity in public. 4 circuits have so decided by the time of the events here. This robust consensus of cases of persuasive authority suggests that if the Constitution protects one who records police activity, then surely it protects one who merely observes it, which is a necessary prerequisite to recording. Our circuit in particular has been quite forthright in upholding the rights of citizens to engage with officers while they perform their duties. For example, in a case called Holland v. McMoney, we held that officers did not have qualified immunity to arrest a man who watched the officers arrest his wife and even shouted at them. We acknowledge that the man was shouting criticism at the officers while they tried to effect an arrest, but we averred to the principle from Walker that public officials have no privilege to avoid public scrutiny and criticism of their actions. Surely, if officers cannot see someone who criticizes or curses at them while they perform official duties, they cannot see someone for exercising the necessarily included right to observe the police in public from a distance and without interfering. So as the Court of Appeals is pointing out here, there's been quite a lot of case law on whether or not a person has the right to record the police, because the police have repeatedly arrested people for doing nothing else other than recording the police. And as they point out here, every circuit that has considered this question has said, yes, an individual has a right to film the police, as long as they're not interfering, as long as they're not preventing the police from doing their business. So as long as they're standing sufficiently far away and not getting involved, there's probably some sort of like cone of distance that like you could get too close to the action that you'd be perceived as being part of it. But if you're standing like 20 feet away, 30 feet away, probably okay. And if you're recording and just behaving passively, that's okay. Every circuit who have considered this has said it's okay. And God thank us all for that. We as the public have the right to watch the police, and as much as they have the right to watch us, right? And so the court here is saying, like, look, if you have the right to video this, surely you have the right to observe. And all he's doing is observing. So you have no probable cause to do anything. You should let him about his business. So police have to learn once again that we, the people, have the right to observe them, right to film them, the right to criticize them. This does not qualify as obstruction. Obstruction of cop is not a statute. No. Contrary to the dissent's suggestion, we do not hold that Wallace was prohibited from investigating Graham's concerns. He certainly could have asked Graham for more details, kept a close watch on Chestnut, or approached and spoken with him about his presence in the park. We merely hold it was clearly established at the time that he could not detain him without more indication of wrongdoing. Since Wallace could not reasonably believe that Chestnut was engaged in or about to engage in criminal behavior, we think it is also beyond debate that Wallace should not have believed that Chestnut was armed and dangerous, which would have justified him being frisked and handcuffed. By all accounts, Chestnut was calm during the incident and did not behave erratically, nor did Wallace even conduct a basic investigation into reasons for Chestnut's observations before frisking and handcuffing him. While Wallace testified that he had learned through dispatch that Chestnut was hiding, lurking, or peeking between the trees, assertions that he repeats liberally in his briefs, the audio recordings of the radio conversations undermine this testimony. The only relevant information related to Wallace was that Graham said that Chestnut was suspicious, and following her as she performed traffic stops. A vague conclusory statement that a person is suspicious is insufficient to specifically to support detention by police, and merely observing police officers at work cannot give rise to reasonable inference that criminal mischief is afoot. Graham did say that Chestnut was leaning against a tree, but that seems to indicate a casual observer, not a threatening presence. So that is the end of the case of Kevin Chestnut versus Officer Darwin Wallace of St. Louis. In this case, we learned that Mr. Chestnut was in a park and saw some traffic stops occurring and decided to stay and watch. Another police officer found this suspicious and decided to investigate. They asked him for some information. He gave some information, not others. They then decided to detain him by putting cuffs on him, which was improper because they did not have any reasonable suspicion that he was engaged in any criminal activity. This person had the right to simply walk away if he wanted, and he had the right to give information if he wanted or not. And so the police acted improperly here by detaining an individual without even reasonable suspicion of any criminal activity. And the court holds here that there is generally a right of people to both film and observe police officers. And that is the end of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.